Aditya, we are live now.
Good morning, everyone. I, Aditya Giri, Member Executive of Supreme Court Advocates on Record Association, welcome you all to today's session of the ongoing Scora Lecture Series, where we bring leading minds to explore critical aspects of law and governance that shape our nation's future. We are honored to have with us today Mr. Vikas Singh, Senior Advocate of the Supreme Court of India, who brings with him decades of distinguished experience in constitutional law. Today's topic: reforms in higher judicial appointments could not be more timely or relevant as our democracy continues to evolve. The process of appointing judges to our higher judiciary remains a subject of intense debate and discussion. The balance between judicial independence and accountability, the need for transparency in appointments, and the quest for maintaining the highest standards of judicial excellence are all critical aspects that demand our attention. Mr. Singh's lecture today promises to shed light on these complex issues and offer valuable perspective on potential reform that could strengthen our judicial system. His unique position as a senior member of the legal fraternity enables him to provide both critical analysis and constructive suggestions for improvement. Now, I request my friend and colleague A. Selvan Raja to introduce our today's speaker. Please, Selvan.
Good morning, everyone. Even though Sir would not require any introduction, but still, as a duty of mine, I just give a brief introduction about Mr. Vikas Singh. Mr. Vikas Singh is an eminent senior advocate practicing in the Honorable Supreme Court of India. With a standing of over 34 years at the bar, he has been the Additional Solicitor General of India from 2005 to 2008 and has been elected as a President of the Supreme Court Bar Association for 3 times. His contributions to the field of law and public life are significant. As a law officer for the Government of India, Mr. Vikas Singh successfully represented the government in a wide range of matters, including constitutional law, administrative law, contractual disputes, service matters, taxation, coffee posa, NTPS, company law, government policy, preventive detention, and more. In these cases, he secured landmark rulings from the Supreme Court while diligently defending the government's interests. Many of his judgments have been reported in leading Supreme Court journals and frequently cited in authoritative legal texts, underscoring their significance. Notably, Mr. Vikas Singh was appointed as a special prosecutor by the government of NCT Delhi in the high-profile Abu Salan trial. Mr. Vikas Singh has also been a visiting faculty member at the Indian Parliament, delivering lectures to foreign delegates on topics including legislative drafting and legal education. Following the events of 9/11, he introduced a theory of legislative control on terrorism during an address to international delegates at the Indian Parliament, advocating for legislation to prohibit the media from publishing photographs of terrorists to deter terrorist organizations from seeking publicity. The articles authored by Mr. Vikas Singh on blemishes in the collegium system on appointment of judges has been widely published and received appreciative attention of the judiciary and legislature. He has in fact suggested that the government should be well within its right to bring in a bill to regulate the collegium system so as to ensure that people of high integrity and merits and high caliber are only considered for appointment to the higher judiciary. Being a vocal protagonist of separation of powers, Mr. Vikas Singh has strongly objected whenever courts have may try to overstep into the domain of executive. Mr. Singh represented numerous eminent personalities from the business and political worlds and frequently appears in pro bono cases involving issues of am I audible? Involving issues of national or public interest, such as the decriminalization of politics and matters recognizing his expertise. And recognizing his expertise, the Vice Chancellor of University of Delhi, on behalf of the Academic Council, nominated Mr. Singh as a member of the Faculty of Commerce and Business. Considering the importance of far-reaching implications of the Mediation Bill 2021 on the dispute resolution system of the country, the Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice sought expert suggestions and comments on the said subject from Mr. Vikas Singh. While holding the position of the President of the Supreme Court Bar Association, he had taken various key steps for the welfare and long term financial security of the members of the bar, along with various other steps to improve the overall infrastructure available for the members of the bar. Beyond his legal career, Mr. Vikas Singh is dedicated to social causes. As the chief patron of the Delhi Foundation of Deaf Women, he is committed to supporting children with disabilities. He actively promotes the education of girls, emphasizing that educating a girl means educating a family. He is also the patron of Tamanna, an NGO founded by Padma Bhushan awardee Dr. Shyama Shona, which has been doing exemplary work with special needs children in Delhi for nearly 4 decades. Additionally, Sir serves on the board of trustees of the Sai Temple in Greater Noida and is a devoted follower of Lord Tirupati, whom he visits annually since 1989. In recognition of his outstanding contribution to the field of law, MIT University conferred upon him the Doctor of Law on 12th November 2022. An avid tennis player, Mr. Singh, represented the International Lawn Tennis Club of India in a tournament at Wimbledon in 1999, hosted by International Lawn Tennis Club of Great Britain on their 75th anniversary. Mr. Vikas Singh's extensive legal experience provides him with a unique edge in the legal profession, enabling him to offer precise and practical legal advice to achieve the best outcomes in any case. Sir, over to you.
First of all, I must thank Skora for this lecture series, and I must congratulate Vipin, Nikhil, the entire team, Kaustubh, everybody, Kaustubh, who have taken this effort of starting this series, which will be helpful for the young members of the bar, and I'll also get an opportunity to share my insight into a subject on which I feel very strongly about. This is one subject which, in my tenure as the president of the Supreme Court Bar Association, I have always taken it up in a very, very strong way to, sort of um, see that the present system that is being followed for judicial appointments get improved, or rather are, sort of reinvented, because the whole process of judicial appointments, although should be with this system of collegium system, but the way it is being implemented is something which is one has a lot to say about. It's also interesting that Skora is organizing this series because it is the Skora's petition which for the first time decided on this appointment process, and the judge's appointment was decided that it will be done by this system. When you see the Constitution and read the Constitution provides for the appointment of the judges of the higher judiciary, especially the High Court and the Supreme Court, by the President of India. And before making such appointment, he consults the senior judges, the Chief Justice and the other judges of the Supreme Court before making the final appointment, or rather before issuing the final notification. Now, our democracy, which when we became independent in 1947 and we drafted our constitution in 1950, we had a very committed political environment at that point of time of very eminent people with very high integrity. And accordingly, in the initial years, it was not felt that there was any need to change the process of appointment of judges. And the system, according to me, was going quite well till we realized, until we saw the deterioration in public life, the criminalization of politics, and also the supersession of honest judges only because they were not pliable to the views of the executive. It is in this background that the appointment of judges issue engaged the attention of the Supreme Court. And the Supreme Court felt that this evolution of the Constitution in the manner in which it has been, implemented, there is an urgent need to ensure that the judiciary remains completely away from the executive so that there is no impediment or there is no fetter in the impartial functioning of the judiciary. It is in this background that this appointment of judges case engaged the attention of the Supreme Court, when the Supreme Court said that the consultation will mean primacy to be given to the Collegium of the Supreme Court as the last word for appointment of judges. While the legal determination of appointment of judges by the collegium system, according to me, is the correct way forward for an evolving democracy like India, which has its very unique problems, unlike other democracies of the world. In other democracies, you will see, like for instance, whether it be UK or whether it be US or the other major democracies of the world, corruption has not percolated there, at least in public life. Even a prime minister will get a ticket. You'll get your routine things done without corruption. Corruption may be there at high places in the other democracies, but our democracy is very unique, where our experience has shown that corruption has percolated into at every level of the administration, starting from the lowest in bureaucracy to the highest in the executive, with the result that large number of our politicians are facing criminal cases of various kinds, which definitely impairs their ability to give any, I would say, control or have any control over the appointment process in the judiciary. So this system of appointing judges being away from the executive was definitely a welcome step, especially at the time when the decision was taken in the evolution of our democracy. But the sad part is that the assuming power and assuming the authority to appoint judges comes with a huge responsibility. And the responsibility is to look at the right names, appoint the right names, and ensure that only the best get appointed to the judiciary. Our experience has been, and it is a sad state of affairs as far as that aspect is concerned, that although the appointment process has rightly been taken away from the executive, but the manner in which the appointments are being done is something which is, not a very healthy state of affairs, and there is a complete lack of transparency in the appointment of judges. So when we talk of appointment in judiciary, I'll just give a very small example. When we talk of appointment of judiciary, one segment of our society, which is almost 50% of our population is of women. But unfortunately, in the higher judiciary, their representation is very, very abysmal. And the two professions in our country, politics and judiciary, especially the higher judiciary, has really become a male bastion. So when you see appointment in the lower judiciary, which is by merits, which is by an examination, an interview, you will find about almost 40% appointments are of women without even there being any reservation for them. Whereas in the higher judiciary, this percentage comes down to hardly 10 or 12%, which is very, very, deplorable, because there is something wrong in the system that we are not able to elevate sufficient number of women judges to the higher judiciary. And the process definitely lacks some kind of transparency as far as the appointment process is concerned. Now, many a times you will get answers from the judges, and especially the outgoing Chief Justice of India, although he used to always advocate of promoting the numbers of appointment to the higher judiciary, he hardly did anything in his entire tenure to appoint women judges. The argument given many a times is that the sufficient number of women are not practicing in courts, and accordingly, it is not possible to find good women lawyers to be elevated. And with the result that the process of elevating more number of women will take time, because now that young girls have started coming in large numbers in the profession, probably 15, 20 years down the line, more women will be there, and accordingly they'll be able to justify, or they will be able to appoint more women to the higher judiciary. That's the stock answer which is given, which was given by the outgoing Chief Justice of India, and which is what the standard answer is in a debate when the judges are to answer a query of this kind. In my view, this is completely a lame excuse, because women, by their very nature of the responsibilities that they have to perform in their families and for their children, and for ensuring that the family is taken care of properly, do not prefer the legal profession by coming into litigation. But nevertheless, a large number of women get into the profession in law firms and in other legal jobs which are available in-house with companies. If you really feel that you need to give women sufficient representation, I don't see why you cannot consider women who are working in law firms, who don't come in front of you on a daily basis, and identify them for the purposes of elevation, so that, or even pick up good law officers who are in the lower judiciary, because there the numbers are sufficient for direct elevation to the Supreme Court rather than getting into the promotee quota. So this is again a complete lame excuse. There is complete lack of will in trying to identify the right people in appointment of judges, and that is why you feel such a abysmal representation of women in the higher judiciary. Now, when we talk of appointment of women, and we emphasize the aspect of looking outwards to find out the right people, then that automatically springs up the malaise of appointment of even male judges to the judiciary, or rather all appointments to the higher judiciary. Unfortunately, whenever you talk of appointment to the high courts, the all question every time being asked is, and according to me very wrongly, that the Chief Justice or the collegium judges don't know a particular lawyer, and accordingly they are not in a position to recommend his name for elevation. Now, according to me, this is completely belying the very purpose for which you took the process of appointment into your own hands, because it is not humanly possible for the collegium judges to know all the available, or I'd rather say, all the talent that is available in the profession to be considered for appointment. Now, when the judges perform this task of selecting names for the higher judiciary, or for the appointment to the High Court, and even to the Supreme Court, because we have had a lot of instances where direct elevation from the bar has happened to the Supreme Court, they also perform a very important role in deciding to elevate lawyers as for the purpose of senior designation. Now, when you have lawyers in the profession, and when you have to do futuristic planning that the entire profession progresses in a very holistic manner, then you have to identify who are the material who should be considered for senior designation, which is also a very important requirement for the purposes of ensuring a robust judiciary, and who will be a good candidate for becoming a judge. Invariably, we have seen people who are more suitable to remain in the profession as a senior advocate and to contribute to the profession in the process, many times get appointed as judges, and the real people who need to be appointed as judges are not even considered. The, the second judge's case, the NJAC, was struck down primarily on the ground that the executive in the process of appointment was having a primacy on the final list that is to be cleared for appointment to the judiciary. The NJC although had another feature, obviously, which was not commented upon by the judiciary, which was with regard to the having a system of deciding a list of eligible people who should be, I think, इसको ऑफ करना पड़ेगा एक्चुअली। ये क्या है ना कि इससे वो फोन आ रहा है तो उसमें चला जा रहा है। Let it go back.
So you can continue.
Yes,
You
sir.
can continue.
You are audible, sir. Loud and clear.
Actually, I can't see myself on camera.
So because you're live only, you can be seen
Yes,
by
yes.
everyone.
Okay. So, so the NJC had another feature, which was with regard to, selecting the right people, having a panel, having a eligibility, and on that basis, इसको मत खुलने मत दो उसको. Having an eligibility. Obviously, nobody commented on that because the case went on a different spin altogether, and rightly so, that if the primacy goes to the executive, then the whole purpose of having a system of appointing by the collegium will get completely defeated. Now, when you talk of appointment to the higher judiciary, I don't understand why there cannot be a system by which you have, firstly decide an eligibility. So for instance, every high court, there could be a minimum threshold of income. There could be a threshold of a certain number of reported judgments. There could be also a criteria which is there for the senior designation of having done pro bono work, because ultimately, when you become a judge, you have to, give up, if you are doing well in the profession, a lucrative practice. So there has to be an element of service in you, which you will exhibit as a judge when you are appointed. And on all these criteria, there could be a permanent committee which could be considering all the names, whether in the high court or whether in law firms or whether in lower courts, lawyers practicing in lower courts. And also, when you make this panel, you have also to ensure that you consider subject-wise as well. So people in service law are also required, people in tax are required, people in criminal law are required. All these kind of people are to be considered. And then once you have the panel, the making of the panel is not an activity which either the SCORA judgment or the NJC judgment will fault, because that is only a creating a list of eligibility. When you create a list of eligibility and when you have all the data with you, then the data should ultimately, the final data should go to the collegium only. And then the collegium should discuss every name before deciding who should be elevated. If you don't do this exercise, what happens is that people who are known to the judges in the collegium ultimately are only being considered, which is why they say that there is nepotism in the higher judiciary. And the statistics also disclose that family members of judges are appointed more easily than first timers or not related persons to the higher judiciary. And that is why the higher judiciary has remained a preserve of a selected few, families, so to say, whether it be of judges or people who are close to the judges. And this brings in a flaw in the appointment process, that ultimately the right talent is not identified for wing elevation. And in this context, I have been taking this up always especially for the members of the Supreme Court Bar Association. Not that I ever feel or I want to ever project that the Supreme Court Bar Association deserves any preferential treatment in the matter of appointment of judges. No, some people try to give it a spin as if my efforts to elevate people practicing in Supreme Court is to give them some kind of a primacy. No, not at all. When my effort has always been that when you make a panel of this kind of eligibility, in that eligibility, why not a Supreme Court? If a lawyer, if I'm saying that a lawyer practicing in law firm should be considered, if a lawyer practicing in the trial court should be considered, I don't see why a lawyer practicing in Supreme Court should not be considered. And our experience has been, and again, when we talk of the judges' appointment case and the way things have evolved over time, it is all because of our experience of corruption percolating in the administration and in the executive and the politicians facing large number of cases, which was the reason for bringing this judgment in the first place. Now, if that is our experience, then our experience has been, and which should be taken notice of, that whenever a lawyer practicing in the Supreme Court has been elevated to the High Court, he does exceptionally well, and the bar ultimately feels that there are judges who are doing good work in the High Court, who are giving relief, who understand matters, who dispose of matters faster. So if that has been our experience whenever you go to the high courts and see the people who have been appointed, especially of people who practiced in Supreme Court, then I don't see any reason why this should not be encouraged, to ensure that more and more number of people who are practicing in the Supreme Court are considered amongst the basket of names to be considered for elevation. And if they are found better than the names which are practicing in the High Court, then definitely should be elevated. Recently, I was in the Orissa High Court and I met some members of the bar, and they were so happy with one of our members who's been elevated to the High Court there, Shibu Shankar Mishra. They said, "Sir, you must send more and more such people to our courts, to the High Court." So this I've felt in every High Court when I go, our people are doing so well that it really, we feel very hard, it's a very heartening feeling to see that members practicing in Supreme Court have done well. So the malaise is not that you're not considering Supreme Court lawyers. The malaise is that you're not wanting to look for the right names to elevate as judges in the High Court. Now, if you just take this a little differently, when you come to the Supreme Court appointments also have a inherent flaw, and the flaw is that that every time an appointment is made, a new criteria is disclosed. So sometimes it is disclosed that this particular judge is a scheduled tribe, and accordingly he will add to the diversity of the institution. Sometimes when a judge is appointed from a state which is unrepresented, then that is taken as a criteria for his appointment. So every appointment that happens has a justification of a criteria which is not followed uniformly. So there are high courts who are overrepresented. There are high courts which are not even represented, not represented at all. And again, a case in point is of Orissa, because Orissa, I believe today has no judge into the Supreme Court. So this system of appoint, either you go for strictly by merit to Supreme Court, or I would be the happiest person, and I think it will be doing great service to the institution if you go strictly by merit and don't go by seniority, don't go by state, go by the best names that are available in the country, because ultimately the Supreme Court is the institution which lays the law for the entire country. It is law of the land. So if that be so, nobody can have a grievance that you are going for the best. And the process for selecting the best also there should be a transparent method of deciding that as well. But if you don't do that, and if you while making every appointment, you decide a criteria and justify an appointment by that criteria which you disclose at the time of appointment of that particular judge, then there is a huge amount of subjectivity which is of the collegium, which is reflected in the appointment of the Supreme Court, appointment to the Supreme Court as well. The other aspect which comes to my mind is that judges, merely because they fulfill a criteria, or like that they have enough number of reported judgments and they have enough number of income, should by itself not be a ground. There should be another factor which should be considered, and unfortunately it is not being considered at all, and that is of people who are decisive. I have seen judges who can hear matters for days on together and still not decide, or rather still decide wrongly, vis-a-vis judges who will decide a matter because their first principles are correct, and they are able to take a call with regard to the matter faster. And when you have a judge who is decisive, the pendency of that judge is far, far better. The disposal of that judge is far, far better than another judge who is unable to decide. Now, this also is a issue which has to be factored in while thinking about elevating persons to the higher judiciary. And the moment and if they don't do this, if this collegium system does not reinvent itself, then I've suggested to the erstwhile law minister also. In fact, he said it in parliament also, that I have drafted a law on a bill to regulate the collegium system. I have also, when I met the Prime Minister in the Law Day function, I told it to him also, and he also agreed with me, at least orally, that this needs to be done. But somehow the will in the executive is also not there, because the very fact that they are not coming up with a bill to regulate the collegium system, I feel that they are also basically wanting to take control over the appointment process, and they're not really bothered for the right people to be appointed to the judiciary. So while the appointment may remain with the collegium, while the final arbiter may be the collegium, but which names they will consider, or what will be the criteria to decide the basket of names which will go to the collegium for the purposes of elevation, can definitely be decided by a law, or by or if the collegium wants to do it itself, by self-regulating its procedure. Because if you don't do this, then the problem that is happening is that the quality of judges will over a period of time go down. And when you want to think of India as a country which will lead the world in the days to come, then you definitely need a very robust and a very impartial judiciary, which can only happen when you have people of very high integrity and very high merit occupying the higher judiciary. Because we have to appreciate that the kind of powers that our judiciary exercises is mind-boggling. a constitutional amendment which has been done by two-thirds members of the parliament can be annulled technically even by a two-judge bench of the Supreme Court. So this is the kind of power that the judiciary wields in the matter of in our democracy. And if we want this power to be exercised with certain degree of integrity and fairness and impartiality, then we need people of very high caliber and high merit to occupy the higher judiciary. And for that purpose, it is high time that we reinvented our process, or the government brought in a bill to regulate the collegium system so that this malaise is taken care of, and this system automatically brings in transparency. And if there are say 30, 40 names or 100 names before the collegium, then to reject a name and to select another name will be a very big exercise. And this kind of exercise, if it is, even if we leave it to the wisdom of the three collegium members in the High Court, or the three in the Supreme Court, or five in the Supreme Court, as long as they consider all the names which are which need to be considered for the purpose of elevation, I think we will be taking a very big step forward to ensure that there is transparency in the appointment process, and the constitution is able to survive the onslaught of this degeneration in public life by the high morals and the high standards that we have in the judiciary. Today, we are facing a situation where in the Supreme Court Bar Association, there is a matter pending in the Supreme Court where judges had to decide on the composition of the executive committee, and they felt that there need to be some lady members for the because they know that the bar is mainly comprising of men. So if there is a vote where two-third majority is required to vote for including a quota for ladies, this will never happen. So they have done it by a judicial order. Similarly, today we are in a situation where Parliament has about 45% people with very serious criminal antecedents in the Parliament. So if you want to bring in a law to debar the people with criminal antecedents into the House, you cannot think of getting a law passed by the Parliament with such high numbers of people with criminal antecedents there. So that is where the judiciary steps in. If the judiciary has stepped in to take over the process of appointment of judges only because they didn't want this process to go to the executive, notwithstanding the fact that in all democracies, or almost all democracies, the appointment of judges, barring few, the appointment of judges are done by the executive exclusively. I don't see why the judiciary should not step in and also decide on cases with regard to barring criminalization in politics. Because when the constitution was drafted, the constitution makers at that point of time had a situation where all the political leaders were facing some kind of a criminal case or the other foisted on them by the British. And accordingly, they could not think of that at that point of time of having this kind of a disqualification. But again, with passage of time, this thought of the society always Dr. Ambedkar said in his address when the constitution was finally being adopted that one of the regrets that he has is that he could not provide for proper qualification for legislators. And one of the qualification could have been a disqualification on the basis of criminality. But he said that our system has always thrown the right people. At the time of the freedom struggle, when some people were arrested, the society used to throw more, the more number of leaders used to come up to take over the mantle of the freedom struggle. So we don't see why our people will not be bringing up good material every time when they elect. But that has been completely belied with our, by what we see in Parliament today. So the time has come for the judiciary also to step up and take the constitution in the direction in which, or rather in the with the vision with which it was originally drafted. And for that, we require men of very high caliber and integrity, and with us, and also who have the moral fiber to be visionaries as far as the taking the constitution in the right direction is concerned. And that is why I say that it is very, very important that the appointments to the higher judiciary are completely made in a very transparent manner, and the best of the best only get appointed. Thank you.
Thank you so much, sir, for your insightful views on the topic today. Sir, we have received few questions. You have already covered a lot of from these. However, I would like to ask you one question: that how might we incorporate international best practices from our democracies into our judicial appointment process while preserving our constitutional framework? So this is one of the question which I might want to ask.
So now, fortunately, we have this appointment of judges case, which has taken over this appointment of judges by the collegium. Now, if you will recall, there is a memorandum of procedure which is to be finalized with the government. And unfortunately, till date, there is no memorandum of procedure which has been accepted, because there has been no unanimity on the memorandum of procedure. Now, having no memorandum of procedure, ultimately the judiciary, the higher judiciary, especially the collegium, is on a completely uncharted path, and they are doing whatever they feel is correct in their wisdom. So if they are doing it in the manner in which they are doing it now, they can always bring in the best practices in their own. So that is why when I meet the judges and when I tell them, or when I was president of the bar, I used to always emphasize that you have to reinvent yourself. And when you reinvent yourself, you can bring in the best practices that are followed in the world to see that you, in the appointment process, go for the best method for appointment, rather than doing this ad hocism of whom the collegium judges know and they recommend, and whom they don't know, they don't recommend. So that is something which is a big pain in our system, which can be corrected by the collegium itself if they want to, by following the best practices.
Very well, sir. Thank you so much, sir. I would request our president, Mr. Vipin Nair, to say a few words.
So, what do we say about after this masterclass on the entire gamut of the appointment of judges? SCORA, as you said, has been at the forefront of the fight for ensuring the independence of the judiciary. As a matter of fact, when I was a secretary, the NJC petition itself was filed. And I remember the interactions we had with the late Fali Nariman, who was actually boiling with rage as to how that legislation was drafted. So whether there was some inherent frailties in that legislation itself, which the Constitution bench thought and struck down, because the primary argument of the Attorney General was that sunshine is the best disinfectant for the system and we should open up and we should transfer. But whether the executive has an upper hand in it is something which the minority judgment also considers. You have very succinctly taken us through the entire thing. Let us wait and watch. There's more action on this front of independence of judiciary. But interestingly, as an anecdote, I believe that the first prominent appointee of the collegium was Justice R.N. Lodha Sahab. And we can see the levels to which he rose. So it's a mixed bag. If you have the good, and then if you have the... So we have to get along with the existing system and wait whether the executive does something. But truly, it has been a great pleasure listening to you, sir. And we'll be interacting with. Thank you on behalf of all our committee.
Thank you so much.
Thank you, sir.
Thank you, Vipin, sir. Now I would request Meenakshi Kalra, Member Executive, SCORA, to give a vote of thanks.
Sir, good afternoon. I, on behalf of the whole executive committee at the Supreme Court Advocate on Record Association, extend a heartfelt appreciation for being a part of the SCORA lecture series And thank you, sir, for enlightening everyone on the reforms for the appointment in the higher judiciary. I think this topic was wonderful topic and everybody will be a lot enlightened upon it. It was gracious of you, sir, to recognize that there is a need for the presence of women and the women representation in the higher judiciary. Also, your lordship, you, sir, also recognize that the appointments in the higher judiciary should shift from a selected few to identify the right talent, and also that the meritorious appointment should be there and a transparent procedure should be adopted for the appointment in higher judiciary. Thank you, sir, for giving an inputs on the criteria, that there should be a criteria for appointment uniformly in the higher judiciary. I thank you again, sir, for your gracious presence, and we look forward to have you again on board for the Scholar Lecture series.
Thank you. Thank you so
Thank you,
much.
sir. Thank you.
Thank you, sir.
Thank you.